Good day to each and everyone, ladies and gentlemen. Welcome to the third video presentation for the subject Fundamentals of Criminal Investigation with Intelligence. No? And in this third video presentation, we will talk about the welfare of victims since in criminal justice system, a lot of people state that the forgotten people in the criminal justice system are the victims at wala daw silang karapatan, no? Dito sa video presentation na ito, ay i-discuss natin kung ano yung kapakanan ng mga biktima, no? Ano yung kanilang karapatan. Yan po, no? So para maging sensitive yung pong future law enforcers natin at kayo po yun, no? At alam nyo na meron palang karapatan din ang mga biktima, no? Kasi sinasabi nila na mas marami pang karapatan ang binibigay ng ating pamahalaan sa mga offenders na nakagawa ng krimen. Pero tama po yun. Ano? Mas marami pong karapatan ng offenders kaysa sa victim. Pero meron ding karapatan at may mga batas na nag-aalaga sa kapakanan ng biktima. No? So since this is a continuation of the first and second video presentation, pag hindi mo pa napanood, panoorin mo na. Now, our objectives at the end of the lesson, we should be able to apply the knowledge on RA number 7438, which we have discussed in the second video, as well as 9745 and UN Convention on Human Rights. In the first video presentation, we have presented the Article 3 of the Bill of Rights, no? And we have given emphasis to the rights of person detained, arrested, and under custodial investigation, no? Second, you should be able to exemplify and implement appropriate laws pertaining to the welfare and protection of victims. Third, recognize and implement the rights of the accused and victims' welfare. So you should be able to recognize it correctly. Once I will give you a question, then you should be able to answer it correctly. Okay, so let us start with the discussion for the welfare of victims, no? And what are the statutes that was passed to give rights, no, to victims. Okay. So first law, we have Republic Act number 7610. It is an act providing for a stronger deterrence and special protection against child abuse, kasi ang usual po na naaabuso, ano, ay mga bata. Yan. So, ang ating batas ay nagbibigay po ng special protection of children against abuse, exploitation, o yung paggamit, no? Ginamit mo ang isang bata para sa iyong pansariling kapakanan, this exploitation and discrimination, and for other purposes. The act shall be known as the Special Protection of Children Against Abuse, Exploitation, and Against Discrimination. So, wala pong bata dapat na dinidiscriminate, okay? Inaabuso, ginagamit lamang para sa pansariling kapakanan. Yan. At ang isa pang napaka-importante dito, tandaan nyo, kapag ang isang tao ay less than 18 years of age, he is considered as child. Therefore, he or she is under the special protection of our government. Okay? So, meron pong isang kaso na nangyari noon, no? Ano po ang nangyari doon sa kaso? Yung pong isang 17 years old ay nakipagrelasyon sa isang adult. Ibig sabihin, more than 18 years old yung karelasyon. Ngayon, yung pong magulang, nung pong 17 years old, ay nagsampa po ng kaso. That is violation of RA 7610. No, dahil nga nakipagrelasyon yung kanilang anak doon sa adult. Ngayon, sabi nung adult na nung sila ay nagkaroon ng pagtatalik, ay yung babae ay pumayag naman, kaya walang rape. Pero tandaan, hindi naman rape yung ikinakaso, kundi violation ng 7610. So ano pong nangyari? No? Yung pong adult ay convicted sa violation ng 7610 for having a sexual relation with a minor or with a person who is less than 18 years old. Kahit pumayag pa yon, no? Hindi naman rape yung ikinakaso, kundi violation ng 7610. Why? Because a person who is less than 18 years old is still under the special protection of our government against child abuse, yan, exploitation and discrimination. Okay? So, yan po ay considered po siya as child abuse. No? Yan. So, tatandaan nyo, yung pong mga andito na mahilig po sa mga senior high. Okay? Yan, no? So, alam ko naman na kayo po ay more than 18 years old na. Mag-ingat. No? We have also Republic Act number 9262. It is an act defining violence against women and their children and providing for protective measures for victims, prescribing penalties therefore and for other purposes. It shall be known as the Anti-Violence Against Women and Their Children Act of 2004. No? So ito po ay nagbibigay proteksyon sa kababaihan at sa mga bata laban po sa violence. Okay? So kung makikita natin, ang dami pong batas na naipasa para protektahan yung pong mga bata at mga babae sapagkat sila po yung vulnerable, no? Vulnerable part of the society to crime. Kasi nga, they are considered weak. Okay? So yun po ang sabi ng batas, no? That's why they should be protected. That's why Republic Act number 9262 was passed. Okay? Para yung pong mga lalaki na nananakit ng asawa at kanilang anak ay bigyan ng parusa kung sila po ay mang-aabuso o aabusuhin yung pong kanilang asawa at yung kanilang anak. No? So under the VAUSI, kung narinig nyo na ang VAUSI, that is Violence Against Women and Children. VAUSI po yun. Ano? A petition for protection order may be filed. A protection order is an order issued for purposes of preventing acts of violence against a woman or her child specified and granting necessary relief. Okay? So, pwede pong mag-apply po ng barangay protection order. Yan. So, mula sa barangay, yung isang inaabuso na babae at yung kanyang anak, yung inaabuso ng kanyang asawa, para sa ganun ay sila po'y proteksyonan laban sa pang-aabuso ng pong mga nang-aabuso. No? So the protection orders that may be issued are barangay protection order. It is a protection order given by the barangay, of course, for the protection of the children and of course the child. Children and the wife. So para sa mga babae ito, ano, wala po sa lalaki. Sa mga kalalakihang nakikinig dito. Okay, so temporary protection order or TPO and permanent protection order or TPO. Okay, so it can be applied in barangay or pagka in-issue po sa munisipyo, syempre, yan po ibibigay ng ating Women's and Children's Protection Desk. Okay, yan po. So we have also Republic Act number 6981. It is an act providing for witness protection. Okay, protection of witness to give their security. Yan. So the title of the law, an act providing for witness protection and security benefit act and for other purposes. The name of the act shall be known as Witness Protection and Security Benefit Act. Okay, so ito po yung batas na nagbibigay protection sa mga witness. Kadalasan, yung pong mga witness din, yung mga biktima ng krimen. Diba? Yan. Pwede rin namang maging state witness, yung isang taong sangkot sa isang krimen. At yan po yung ating pag-uusapan po dito sa batas na ito. Ito po yung napaka-importante, ano? Sapagkat kung ang isang witness mo ay natatakot na magbigay ng testimonya dahil baka siya po ay balikan, so ito po ang pwede mong i-promise sa kanya, no? Yung pong special protection or protection, no? Or witness protection under 6981. So huwag niyong kakalimutan yung batas na ito, no? So Section 2, implementation of programs. Sinong nag-i-implement? The Department of Justice, hereinafter refer as the department through its secretary shall formulate, implement witness protection and security benefit program. So under po yung programa sa Department of Justice, no? pursuant and consistent with provision of the Act. Okay? Then the department, that is the Department of Justice, may call upon any department. So pwede nilang tawagin yung pong Philippine National Police, no, as a bureau or other department or office in any other executive agency to assist in the implementation of program, and the latter offices shall be under the legal duty and obligation to render such assistance. So kung nag-apply ka po ng Witness Protection and Security Benefit Act, no, or yung Witness Protection Program, then ang magre-render po ng serbisyo ay depende po kung sino pong aatasan ng Department of Justice, no? Yan. So napakalinaw po, mas malinaw pa sa araw, no, kapag ka makulimlim. Yan, no? So Section 3, admission into the program. Paano ba ma-admit ang isang tao para maging witness? Diba? So sino ang na-admit bilang witness at makaka-avail ng protection? Diba? So who can be admitted in the program or in the witness protection program? Who can be admitted? Any person, hindi po kabayo, hindi po animal, no? Who has witnessed or has a knowledge or information on the commission of a crime and has testified or is testifying or about to testify before any judicial, sa korte, quasi-judicial, parang korte ang trabaho, pero kasong administratibo or doon sa legislative body, no, tulad ng Senate, Blue Ribbon Committee, yan, quasi-judicial yan. Or before any investigating authority may be admitted into the program. So tandaan, meron siyang knowledge dahil nasaksihan niya ang isang krimen, meron siyang knowledge, meron siyang alam na facts about the commission of crime. Okay? So yun po yung unang requirement. Okay? Second, ay ikaw po ay nag-testify na. Okay? Medyo delikadong kaso, nag-testify ka na. Nagte-testify pa lang kasi kasalukuyan dinidinig yung kaso or magte-testify pa lang. Yan, sa korte or quasi-judicial. Oh, has testified, tapos na. Testifying, nagte-testify kasi yung kaso dinidinig, no? Or about to testify, magte-testify pa lang kasi didinggin pa lang yung kaso. Okay? So yon, so pwedeng ma-admit. Yeah? Meron kang knowledge about sa crime, then you are testifying or you have testified or is about to testify. Tandaan. Provided that the offense in which his testimony will be used is a grave felony. No, grave, no, grave, grave felony as defined under revised penal code or its equivalent under special laws. Yung pong punishable ng presyon mayor pataas, mga grabe na felony. Okay, yung pong punishable ng 6 years and 1 day to 12 years and above. Grabe na felony. Okay? So yun po. Another requirement, his testimony can be sustained or substantially corroborated in its material point. Okay? Yung kanyang testimonya ay kaya pong i-corroborate in its material points. Meron pong binibigyang linaw ang kanyang testimonya. At yun po ay suportado ng ebidensya. Diba? Oh, another requirement, he or any member of his family within a second civil degree of consanguinity or affinity, no, by blood or by marriage, no, is subjected to threat. No? Tinatakot po sila. Yung kanyang kapamilya napapatayin, gano'n. No? To his life and bodily injury, or there is a likelihood that he will be killed, forced, intimidated, harassed, corrupted, to prevent him from testifying or to testify falsely or evasively because on account of his testimony. Okay? So sila po tinatakot dahil nga siya ay magbibigay ng testimonya, tinatakot siya na siya ay papatayin o kaya sasaktan, ganoon din ang kanyang kapamilya, o kaya naman ay may tendency na siya ay bumalimbing at hindi na mag-testify dahil baka siya po ay matatakot. So kailangan nga naman ng protection para matanggal yung kanyang takot, no? And the fourth, no, requirement, he is not a law enforcement officer, even if he would be testifying against other law enforcement officers. Take note, mayroong discrimination, ano? Pag police, hindi pwedeng maka-avail ng witness protection program. Okay? Pag law enforcer, hindi po pwedeng mag-avail ng witness protection program as specified under 6981. That the person who is applying for the witness protection program is not a law enforcement officer. Kahit na nagte-testify ka pa laban sa isang pulis. Di ba? So in such case, only immediate members of his family may avail themselves of the protection provided under this act. Yung kapamilya ng pulis pwedeng mag-avail. Pero yung pulis mismo, kahit nagte-testify pa laban sa kanyang kapwa pulis, kahit mas mataas pa ang ranggo sa kanya, ay hindi po pwedeng mag-avail ng witness protection program na nakasaad sa RA 6981. So, sinong pwedeng mag-avail? Civilian. Diba? Civilian. At yung asawa ng pulis. Yan, no? So, that is under Section 3. Tungkol sa mga pwedeng ma-admit bilang or maka-avail, no, dito sa witness protection program. Okay? Next section, witness in legislative investigation, like for example in Blue Ribbon Committee in the Senate, no, or Senate hearing, no. In case of legislative investigation in aid of legislation, a witness with his express consent may be admitted also into the program upon the recommendation of legislative committee. Kaya nung nangyari kay Napoles, di ba? He became a state witness against those corrupt officials. Okay? So, the witness, no, in legislative investigations can be a witness with express consent, may be admitted into the program upon recommendation by the legislative committee. So ano mo example ng legislative committee? Napaka sikat po ng Blue Ribbon Committee ng Senate, no? Para sa mga cases ng plunder and so on and so forth. Where is testimony needed when judgment there is pressing necessity, therefore, provided that such recommendation is approved by the President of the Senate and the Speaker of House of Representatives, as the case may be. Okay? So kailangan bago po ma-admit sa Witness Protection Program, kailangan po ng recommendation ng President ng Senate or Senate President and the Speaker of the House of Representatives so that that person can be put under Witness Protection Program. Okay? So kahit legislative hearings. Section 5 provides the Memorandum of Agreement with person to be protected. So meron pong MOA ito, meron pong kasunduan. Before a person is provided protection under this act, he shall first execute Memorandum of Agreement. Yan po yung kasunduan, ano? Memorandum. Kasunduan ng dalawang partido which shall set forth his responsibilities. So nakasaad po ang kanyang responsibilidad pagka siya po ay ma-admit sa programa. Ano yung responsibilities niya? Una, to testify before and provide information to all appropriate law enforcement official concerning all appropriate proceeding in connection with or arising from activities involved in the offense charge. So magbibigay ng kanyang testimonya, no, sa appropriate law enforcement officials. Second, avoid commission of crime while under the Witness Protection Program. So wag dapat gagawa ng krimen. Third, to take all necessary precaution to avoid detection by others of the facts concerning the protection provided him under this act. So pagka sinabi ng pulis na hindi pwedeng gumamit ng cellphone, hindi siya pwedeng mag-Facebook, hindi siya pwedeng mag-Messenger, so kailangan niya pong sundin, no? Because those are the precautions so that he will not be detected ng kalaban. Okay? Especially kung yan po ay witness, laban po sa mga nice people around, sa mga terrorists, yan, di ba? Fourth, he should comply with legal obligation and civil judgments against him. Fifth, to cooperate with respect to all reasonable requests of officers and employees of the government who are providing protection under this act. Okay, so cooperation. Doon po sa mga nagbibigay sa kanya ng protection. And last but not the least, to regularly inform the appropriate program officials of his current activities and address. So kailangan po, no, na kapag wala pong ibinibigay na housing sa kanya, for example, no? Siya yung minomonitor lang, so regular dapat na i-inform yung pong mga officials, no? Appropriate officials na nagpoprotekta sa kanya for his security or protection. Section 6 provides for breach of Memorandum of Agreement. Paano kapag nilabag, no, yung agreement? Okay? Meron siyang nilabag doon sa kanyang Memorandum of Agreement. Anong mangyayari? Substantial breach of the Memorandum of Agreement, lumabag siya doon po sa nabanggit natin sa Section 5, no, shall be ground for termination of protection. I-terminate na, no, yung protection provided under RA 6981. Provided, however, that before terminating such protection, the Secretary of Justice pa rin shall send notice to the person involved of the termination of protection provided under this act, stating therein the reason for such termination. Okay? So, anong mangyayari? Yung pong Secretary of Department of Justice will send notice that he is terminating the protection given by the government to the person who was granted for the protection program. Section 7. Ito, napaka-importante po ito, no? So, Section 7 provides confidentiality of the proceeding. Okay? So, all proceedings involving the application for admission in the program and action taken thereon shall be confidential in nature. Hindi mo dapat ipag-chismis na ikaw ay may pinoprotektahan na under or nag-undergo or na-admit sa witness protection program kahit ikaw pa isang pulis, no? No information or documents given or submitted support thereof shall be released except upon written order of the department or proper court. O wala pong, sabi dyan, dokumento na dapat mailabas or impormasyon na dapat ma-release kahit pa sa media, no? Regarding the person to be protected. Okay? So, any person who violates the confidentiality of the said proceeding shall, upon conviction, be punished with imprisonment of not less than 1 year, but not more than 6 years, and deprivation of the right to hold public office or employment for a period of 5 years. Ang saklap nito. Pulis ka na violate mo yung confidentiality, no? Dahil ipinag-chismis mo na yung pong isang tao ay pinoprotektahan ninyo, witness sa ganito, no? So, anong nangyari? Napatay yung witness, for example, because of the information na nag-leak dahil sa'yo. Okay? So, anong mangyayari? Ikaw ay kakasuhan for violation of 6981, no? At kung convicted ka, ay makukulong ka ng 1 taon hanggang 6 na taon. At hindi ka pa pwedeng bumalik sa public office, no? So in any government office for the period of 5 years, ladies and gentlemen. Ang saklap nun. Okay? Ayan. So, do not violate the confidentiality of the proceeding if a certain person was admitted to the witness protection program. Next, no? We have Section 8, rights and benefits. The witness shall have the following rights and benefits. Ito naman yung mga benepisyo ng isang witness, no, na na-admit sa program. To have secure housing facility until he has testified or until the threat, intimidation, or harassment disappears. O, kailangan meron siyang housing facility na ibibigay ang ating gobyerno, no? Yan. So, hanggang mawala yung pong harassment, no, sa kanya. And or reduced to manageable or tolerable level. When circumstance warrant, the witness shall be entitled to relocation and or change of personal identity, no? Papalitan yung nasa birth certificate niya at the expense of the program. Meron po bang ganun, sir? Yes, no? As provided under this program. Okay? So, pwedeng magpalit po ng identity para sa ganun ay hindi po siya madaling ma-identify, no? Lalo na pagka siya nagte-testify laban po sa mga terorista, sa mga organized criminal groups. Okay? This right may be extended to any member of the family of witness within the second civil degree of consanguinity by blood or affinity by marriage. No? Yan. Section 8 po yan, ano? And bravo, Section 8 pa rin, the Department of Justice, whenever practicable, assist witness in obtaining means of livelihood. So bigyan dapat ng trabaho para naman kumita. Para sa ganun matustusan ang pangangailangan ng pamilya. No? The witness relocated pursuant to this act shall be entitled to financial assistance from the program. So kung na-relocate, siyempre walang trabaho, agad-agad, di ba? So, kailangan po ng financial assistance from the Witness Protection Program for his support and of his family in such amount and for such duration as the department shall determine. So bahala pa rin yung Department of Justice na mag-determine hanggang kailan at magkano ang suportang ibibigay. Okay, susunod. Charlie, under Section 8, in no case shall witness be removed from or demoted in the work because or on account of his absences. Kung may trabaho, ano? So wala dapat witness under this program na kahit siya aalis, no? Hindi dapat siya ma-demote dahil nga nag-absent siya, no? Due to his attendance before any judicial or quasi-judicial body or investigating authority, including legislative investigation in the aid of legislation, in going thereto and in coming therefrom, provided that his employer is notified through certification issued by Department of Justice within a period of 30 days, no, from the date when witness last reported for work. Provided further that in the case of prolonged transfer or permanent relocation, the employer shall have the option to remove the witness from the employment. So pwede naman, no, pag na-relocate nga naman, no, permanent relocation na kasi may threat sa buhay ng witness, so bahala na po yung employer. Pero kailangan ibigay niya lahat ng benefits, no? After securing a clearance from department, no, magsisecure pa ng clearance yung pong employer mula sa Department of Justice upon recommendation of the Department of Labor and Employment. Okay? Then, any witness who failed to report for work because of witness duty, nag-duty siya or naging witness doon po sa korte, shall be paid his equivalent salaries or wages corresponding to the number of days of absence occasioned by the program. Kahit nag-absent, babayaran pa rin. Diba? Pagka na-admit sa Witness Protection Program, magsasahod pa rin kahit hindi siya nag-duty. For purposes of this act, any fraction of a day shall constitute a full day salary. So kahit half day lang, babayaran siya ng buo. Diba? So this provision shall be applicable to both government and private employees. So, ang linaw ng batas, ano? So Delta, to provide or to be provided with reasonable traveling expenses, yung pong kanyang traveling allowance, and subsistence allowance with the program in such amount as the department may determine for his attendance in court, body or authority where his testimony is required, as well as conferences and interviews with prosecutor or investigating officers. Ano pa? To be provided with free medical treatment, hospitalization, and medicines for any injury or illness incurred or suffered by him because of witness duty. O nabaril, nagkasakit habang siya ay under the Witness Protection Program, no? So kailangan po ng free medical treatment. Okay? So may traveling expenses, meron pang free medical treatment, no? Yan. So another, if the witness is killed because of his participation in the program, his hire shall entitled to a burial benefit of not less than 10,000 pesos from the program, exclusive of any other similar benefit he may be entitled under the existing laws. Okay? So, hindi po dapat bababa sa 10,000 ang matatanggap ng isang witness na namatay dahil sa pagiging witness. Okay? And next, in case of death or permanent incapacity, maliban sa 10,000 na burial fee, his minor or dependent child, minor, no, less than 18 years old, shall be entitled to free education from primary to college level in any state or private school, college, or university as may be determined by the department as long as they shall have qualified thereto. Okay? So, pag qualified, kunwari meron pong maintaining na average, no, nung bata, kailangan niyang ma-maintain yon. And at the same time, no, hindi po yung bata ang pipili, no? So, doon po sa any state or private school At ang nagde-determine kung saan mag-aaral po yung bata ay yung pong Department of Justice. Okay? So take note of that kasi meron na pong naging programa dyan na meron pong witness na namatay. No? Namatay po yung witness as a result ng pagiging witness niya. Ngayon, yung pong kanyang anak ay nag-apply nga dito po sa scholarship. Okay? So, nilakad po yung scholarship niya. Kaso ayaw niya yung paaralan kung saan siya i-enroll. No? So, anong nangyari? Hindi niya natanggap po yung pong free education. Kasi ang nagde-determine dyan, sabi naman, is yung department. Okay? Yan. At meron pong maintaining na grades. Kaya nga sabi niya, if that person is qualified thereto. Yan, no? Then, Section 9 pertains to the speedy hearing or trial in case where a witness admitted to the program shall testify. The judicial requested judicial body investigating authority shall assure a speedy hearing, trial, and shall endeavor finish the said proceeding within 3 months from filing of the case. So kung may witness protection program po yung kaso, kailangan po hindi po tatagal ng 3 buwan madesisyonan na mula nung ipinail yung kaso. Okay? Para hindi naman masyadong matagal. Yung pong pagpoprotekta din doon po sa witness, mauubos ang budget ng gobyerno yan. Di ba? Section 10, state witness. Sino ang pwedeng maging state witness? Okay? Any person who has participated in the commission of a crime, ito po yung kasama. Kasama po doon po sa paggawa ng krimen at gusto niyang maging witness laban sa kanyang mga kasama. Po pwede ba yun? Yes. Po pwede siyang maging state witness. Okay? So any person has participated, participated in the commission of crime and desires to be a witness for the state. Okay? Pwede ba yun? Yes. Pero may mga qualification. Can apply and if qualified as determined under this act and by the department shall admitted into the program whenever the following circumstances are present. Ito po, yung mga qualification para yung isang taong sangkot sa krimen ay pwedeng maging witness laban sa kanyang mga kasamahan at yung kanyang testimonya ay pabor sa ating estado o sa ating bansa. So ano yung mga qualification? Una, the offense in which his testimony will be used is grave felony as defined under revised penal code or its equivalent under special penal laws tulad ng drug trafficking, tulad po ng kidnap for ransom or kidnapping, homicide, murder, and so on and so forth. Okay? Second, there is absolute necessity for his testimony. So kinakailangan ng kanyang testimonya para makonvict yung kanyang mga kasamahan kasi kulang sa ebidensya. Ayan. Third, there is no other direct evidence available for proper prosecution of the offense committed. So kailangan wala pong direct evidence. Kung walang direct evidence, doon pa lang pwedeng maging state witness ang isang taong sangkot sa krimen kasi nga sangkot siya eh. Diba? So, walang direct evidence, walang direct testimony, laban sa mga akusado. His testimony can substantially corroborated in his material points. Eko, he does not appear to be the most guilty. So kung ikaw po yung most guilty, ikaw po yung ikaw po yung nagplano doon po sa ginawa ninyong pag-kidnap, for example, then of course hindi ka pwedeng mag-avail. Then last but not the least, he has not at any time been convicted of any crime involving moral turpitude. Okay, so yun po yung mga qualifications. No? An accused discharged from an information or criminal complaint by the court in order that he may be a state witness pursuant to Section 910 and Rule 119 of revised rules of court may, upon his petition, be admitted in the program if he complies with other requirements of this act. Nothing in this act shall prevent the discharge of an accused so that it be used as a state witness. Okay? Oh, next, Section 10. Any person who has participated in the commission of crime. Ito yung state witness natin, So, ito po, yun po yung mga qualifications. Tatandaan po yan, Yan. Then, sworn statement before any person is admitted into the program pursuant to the next proceeding, he shall execute sworn statement describing the detail in manner in which the offense was committed, his participation therein. If after the said examination of said person, his sworn statement and other relevant facts, the department is satisfied, then that's the time na pwede po siyang ilagay. If his application admission is denied, the said sworn statement or other testimony given in support of the said application shall not be inadmissible as evidence in court. Okay? So, hindi rin pwedeng i-admit as evidence kahit na po siya ay nag-testify, no, binigay niya kayong kanyang testimonya. Then, effect of admission of witness into the program, the certification of admission into the program may be the department shall given full faith and credit by provincial or circuit prosecutor is required not to include the witness in the criminal complaint. So, tatanggalin na siya doon po sa akusado. Okay, tatanggalin ng prosecutor na pagka nag-grant na siya ay magiging state witness. Okay, the court shall order the discharge and exclusion of the said accused from the information. Admission into the program shall entitle such state witness immunity from criminal prosecution for the offense or offenses in which the testimony will be given or used in all the rights and benefits provided under Section 8 hereof. Okay, kung maalala nyo, yung nangyari kay Napoles, yan, naging state witness laban sa kanyang mga kasamahan. So, compelled testimony. Any witness admitted into the program pursuant to Section 3 and 10 of this Act cannot refuse to testify or give evidence or produce books, documents, records, and writings necessary for prosecution of the offenses, for he has been admitted into the program. Hindi pwedeng tumanggi yung pong isang tao na nag-apply for witness protection program, ladies and gentlemen. Okay? Ang kapalit nun, hindi na siya ipoprosecute, hindi na siya kasama doon po sa kakasuhan. Ganun lang po yun. Then, in case of refusal, paano pag na-admit tapos ayaw na niyang mag-testify? In case of refusal, na-admit siya sa program pero nung nasa korte na, refuse to testify. Ayaw na niya mag-testify. Anong mangyayari ngayon? No? So, he don't want to give evidence or produce books, documents, or writings on ground of rights against self-incrimination. And the state prosecutor or investigator believe that such evidence is absolutely necessary for successful prosecution of the offense. The offense is charged under investigation. He, with the prior approval of the department, shall file a petition with the appropriate court for the issuance of an order requiring said witness to testify. So, pwede siyang i-compel or give evidence. The court, upon motion of the state prosecutor or investigator, shall order the arrest and detention of witness in any jail contiguous to place of trial or investigation until such time that the witness is willing to give such testimony or produce such evidence. Okay? So, aarestuhin na po siya. Diba? Yan, para masigurado yung kanyang pag-testify sa korte. So, Section 15, perjury or contempt. No witness shall be exempt from prosecution of perjury or contempt committed while giving testimony or producing evidence under compulsion pursuant to the Act. The next higher penalty in the degree shall be imposed in case of conviction for perjury. The procedure prescribed in Rule 71 of Rules of Court shall be followed in contempt. But penalty shall be imposed shall not be less than 1 month, but not more than 1 year of imprisonment. Okay, so kung mali-mali po yung kanyang sinasabi, then pwede siyang makasuhan ng perjury or contempt of court, ladies and gentlemen. No? Credibility of witness in criminal cases. The fact entitlement of witness to the protection and benefits provided in the Act shall not be admissible in evidence to diminish or affect his credibility. Okay. Penalty for harassment. Sa mga balak mag-harass, no? Dahil pulis ka, haharasan mo yung witness. Any person who harass a witness and thereby hinders, delay, or prevent or dissuades a witness from attending or testifying before the judicial or quasi-judicial body or investigating authority. O dinelay mo, hindi mo pinayagan yung pag-attend niya doon po sa korte. O yung una. Or you hinders or delay reporting to law enforcement officer or judge the commission or possible commission of an offense or violation or condition or probation, parole, or release pending judicial proceeding. Seeking the arrest of another person in connection with offense, imposing criminal prosecution or a proceeding for revocation of a parole or probation, performing or enjoying right, in benefits under this act or attempts to do so shall be fined with not more than 3,000 or suffer imprisonment of 6 months but not more than 1 year. Makukulong ka. Okay? Hinaharas mo yung witness. Ano? Hinaharas mo yung witness na magte-testify sa korte, magre-report sa law enforcement officer or judge, no? Pinipigilan mo, then pwede ka pong makasuhan, violation dito sa Section 17 ng RA 6981. So pagka nagpulis ka, huwag kayong manghaharas ng witness, no? Yan, o kaya sasabihin nyo, dinidissuade nyo, sasabi nyo, magsabi na hindi totoo. Ayan. So that is the penalty. Okay? 3,000 pesos and imprisonment of 6 months but not more than 1 year. Okay, then let's also proceed to Republic Act number 10364, ladies and gentlemen. Okay, we have the RA 10364. It is the law which amends the Anti-Trafficking in Persons Act. No? So we have Republic Act number 9208 or Anti-Trafficking in Persons Act of 2003 as amended by RA 10364, known as the Expanded Anti-Trafficking in Persons Act of 2012. Ano naman po yung ibinibigay na proteksyon para sa kapakanan ng biktima, no? So what is the protection given to a trafficked person? Ito po ay Anti-Trafficking in Persons Act, ladies and gentlemen. So anong binibigay na kapakanan or karapatan ng biktima under this law, no? The protection given to trafficked persons include legal protection, bibigyan ng abogado, no? Free legal assistance, no? Walang bayad yon. Right to privacy and confidentiality. Witness protection program. Ayan po. So admitted po siya sa witness protection program once a certain person is a victim of trafficking. Victim compensation program. Okay? So meron pong karampatang compensation na ibibigay sa biktima. Who may file a complaint? Sino pwedeng mag-file ng complaint, ladies and gentlemen? The traffic person or offended party, the spouse, yung asawa, no? Parents or legal guardians, siblings, children, or any person has personal knowledge of the offense. So tatandaan niyo po ito. Ito po, agad-agad po, no? Ang isang taong traffic is admitted agad. So witness protection program. At the same time, meron pong victim compensation, ladies and gentlemen. Okay? So hanggang dun lamang yung pong ating pag-uusapan sa video presentation na ito. At sana po ay meron kayong natutunan mula sa inyong Abang Lincoln. Thank you very much for listening. And if you have learned something, don't forget to subscribe and click the bell button and hit also that you will be notified if there will be new videos. Thank you very much and God bless you all. Good day, everyone. See you in the next video.